YouTubers. My name is Jermaine Mop, and today we're going to be talking about the Employment Equity Act of 1998. And this is a ever so controversial act, but we will break it down. But before we start, don't forget to like and subscribe, and please feel free to leave a comment. Okay, let's delve into it. So, given the huge inequalities inflicted by the apartheid era, ensuring equality was one of the primary concerns from the new government, and hence the Employment Equity was born. Now we're going to go straight to the Constitution of South Africa, which states employment equity is enshrined in Section 9 of the Constitution of the Republic of South Africa, which is referred to as the Equality Clause, and states that everyone is equal before the law and has the right to equal protection and benefits of the law. Equality includes full and equal enjoyment of all rights and freedoms, and I know you might not always feel that way when it comes to the law, but that is what was envisioned by the makers of the Constitution. And as you know, Lady Justice is blind, and it's see no faces. It just takes all the information and used on its own merits, and therefore comes with a fair and just outcome. Now, the fundamental result of apartheid was their discriminatory laws and practices in places like your work, your income disparities, employment or occupation, and just everyday life in general was a struggle for one section of the population. So let me just make an example of what I'm talking about. Say you were academically unfit as a white person. The apartheid government would send you on training facilities to obtain skills exclusively only for a white person, and no other person would have access to a place where you can obtain skills. And a black person will be descended into only a domestic worker or a gardener. That's the only skill that you could do, or a manual laborer. And the bar was set a little bit higher for a colored person. You will find a colored person, he will be able to do jobs like a teacher or a police officer or something like that. He couldn't be a doctor, he couldn't be an engineer. So those are the type of things that was happening in the apartheid era. And therefore the Employment Equity Act was so very fundamentally important to address the imbalances of the past and to level the playing field for everybody. So with the new dispensation, there was an urgency to repeal all these discriminatory laws and bring forth new and progressive legislation that will address all these issues. And so to achieve equality, you have to implement affirmative action measures as redress, and that is specifically for a designated group of people. You get two groups of people. You get the designated group and you get the non-designated group. Now the non-designated group is only one group of people that is classified as a non-designated group, and it is only a white male. A white female is classified as a designated group along with all the other groups. Your male colored and your female colored, your black male and black female, Indian male, Indian female. That is all classified as the designated groups, and that is what the Employment Equity Act was trying to address when the affirmative action measures came into effect. I know this is a controversial issue and it might not sit well with others, but this is important that this legislation is in existence. And some people want this law to be repealed, But there's many aspects of this legislation that is fundamentally important, of which you'll obviously learn as we go along. So Chapter 2 of the Employment Equity Act states that it protects employees from unfair discrimination. However, for the purposes of this act, the word employee includes applicants of employment as well. And this is the only place where you will find this in the labor laws. You won't find this in the Labor Relations Act or the Basic Conditions of Employment Act. The word employee means applicants for a job also, because you could be discriminated against as an applicant, and the companies or employers can create a barrier for you for entry, and therefore you can rely on this piece of legislation. So we're going to deal with what is grounds for discrimination. And Section 6, Subsection 1 of the Employment Act states that no person may be unfairly discriminated directly or indirectly against any employee in employment policy or practice on one or more grounds, including race, gender, sex, pregnancy, sexual orientation, age, disability, religion, HIV status, even your conscience or your beliefs, your political opinion, your culture, your language, your birth, or any other arbitrary ground. Now that is very important. That any arbitrary ground has been included into the 2014 amendments of the Employment Equity Act. So let me just explain what arbitrary ground means. So arbitrary ground is something that happens in a company, maybe a policy or a practice that is not clearly defined, and it makes the scope even broader for discrimination. You see, so you get a listed ground and an unlisted ground, but I will explain that a little bit later. But however, we're going to move on to the amendments of Section 11, and that relates to the burden of proof, and we will go into detail about who bears the onus of proof. Okay, now before I go into the burden of proof, I just want to explain something with regards to all labor laws, not only the Employment Equity Act. It relates to the Labor Relations Act and the Basic Conditions of Employment Act and the Employment Equity Act. And labor law works like this. In order for you to prove your case, it works on a balance of probability system. So which means if you take, let's take a scale as an example. If you appear in front of the CCMA, for example, for your case, that is how your case will be measured. What the employer will prove and what you will prove in front of the commissioner, then it will be measured on a balance of probability. So which means if you present more evidence than the employer, you are more likely to win your case. It's not like what happens in the magistrate courts, which uses the Criminal Procedure Act. And the Criminal Procedure Act works on a beyond reasonable doubt aspect. So which means that if, let's say, you've murdered somebody, the state must prove its case on a beyond reasonable doubt basis. If there's any element of doubt, then it means justice was not dispensed correctly. But however, in labor law, it works on a balance of probabilities, and that's just a nice springboard to deal with the next issue, and that is Section 11 of the burden of proof. So Section 11 of the Employment Act deals with the burden of proof, or who bears the onus to prove. And it states that if unfair discrimination is alleged on a listed ground in Section 6, the employer against whom the allegation is made must prove on a balance of probabilities that such discrimination A. did not take place as alleged, or B. is rational and not unfair, or is otherwise justifiable. Now on the other side, if unfair discrimination is alleged on an arbitrary ground, the complainant must prove on a balance of probabilities that A, the conduct complained of is not rational, the conduct complained of amounts to discrimination, and the discrimination is obviously unfair. So just to recap, you get a listed ground, and then you get an unlisted ground, or also called an arbitrary ground. So if your case hinges on a listed ground, and that was everything that was mentioned in section 6 of the act, then it means that the burden of proof lies with the employer, and he must start by leading evidence stating as to why he thinks it's fair. Now, when it comes to a unlisted ground or an arbitrary ground, you as the complainant must prove your case, because you must remember that the arbitrary ground is not clearly defined. It could be anything that is unclear, and that you're going to have to present evidence to state that whatever the issue was, it was unfair. And hence I said earlier on, the new piece of legislation that was put into the 2014 amendments was the arbitrary ground that will cover things that is not really easily seen or where it is a gray area. So in order to succeed in a claim under the Employment Equity Act, it must be established that the employee was subject to direct or indirect discrimination. So you must first find out whether there was a different treatment, or in the law, as they say, differentiation in one or other listed or unlisted ground, as we discussed previously. So I'm just going to give you some examples of direct discrimination and indirect discrimination. Okay, so direct discrimination is on the basis of, let's say, physical appearance or your characteristics or attributes. Differentiation on the basis of your race or your gender, etc., as I mentioned in the act. And the indirect discrimination will be policies or practices that the employer introduces in the workplace. For example, only permanent people that is in the company is entitled to belong to the Provident Fund, as an example, where temporary or casual workers can't access that Provident Fund because they are not permanent. And that for me is completely ridiculous in my view. But these things do happen in the workplace, and that will be regarded as indirect discrimination. So yeah, that is basically the Employment Equity Act in a nutshell. And if you apply all the things you've learned today, you will be able to win your case. And as a final parting shot, I just would like to re-emphasize what the Constitution tells us. And it states that employment equity is enshrined in Section 9 of the Constitution of the Republic of South Africa, which is referred to as the Equality Clause. And it states that everyone is equal before the law and has a right to equal protection and benefits of the law. Equality includes the full and equal enjoyment of all rights and freedoms in our country. And that for me is very important. And if you stick to these principles and values and argue your case in that way, then I will guarantee you that you will be able to win your case. And be mindful and look out for all these discriminatory practices that the employer is doing. And now you better informed and equipped to be able to challenge your employer. Thank you very much for watching, and I hope that you will like and subscribe to our channel. Thank you very much.